back to another edition of Strawman Trust Productions. I am your host, Johnny Strawman, and it is Tell All Tuesday. Now, the first question is more of a subject, and it was proposed by Endless 805. Welcome back to the page. Now, Marbury versus Madison, how I've been synopsized this is, how does Marbury versus Madison protect your constitutional rights? I would argue to some degree that Marbury versus Madison strips you of your constitutional rights. Now, while it is true that Chief Justice Marbury versus Madison said in his opinion for Marbury versus Madison that anything that is repugnant to the Constitution is void, and again, that's true in intent, but what it says specifically is something more along the lines of, certainly although all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of a nation. And consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. Now, understand that he was writing these words, and while the intention behind them is sound at minimum, he was writing them to set the stage to strike down the Judiciary Act of 1789. He was ultimately in a power struggle between the Federalists and the Jeffersonian Republicans under the newly elected President Thomas Jefferson, who was the third president of the United States of America, but in fact, the 13th president of the corporation. Now, the truth is that this was a power grab. It's no doubt that the state, let me say that this is probably the biggest power grab ever attempted in the world, and it was successful. It was orchestrated by John Marshall, and John Marshall was the Secretary of State of the United States under John Adams, the second president of the United States, a one-term president who was ousted in the second election that he ran against Thomas Jefferson, where Thomas Jefferson in 1801, March 4th, 1801, became the third president of the United States. John Adams was routed, and his British mentality, the Tory mentality of they were British sympathizers versus the Jeffersonians, who were actually more French sympathizers. John Adams was routed. The Federalists never recovered from this election where they lost. They were ran out of the House and Senate, and the Jeffersonian Republicans essentially took over. Now, John Marshall was appointed to the Supreme Court by John Adams and by himself during a lame duck session where they wrote an act, Congress wrote an act that was known as, that became known as the Midnight Judges Act, that essentially created all these new judgeships, okay, and made all these Federalist appointments in a session where they had already been elected out. So back then, instead of being sworn in in January, you were sworn in March as the president. So that whole entire time between, that January-March period right there was ripe for opposing parties to do what they would. Now, whether or not that was normally the case, it was the case this time. But John Adams took every opportunity he could to create a Federalist presence and to create a stronghold for the Federalists in the U.S. Supreme Court. So he appointed his own Secretary of State, John Marshall, to the Supreme Court, who then was able to gain the Supreme Court, the Chief Justice title of the Supreme Court, and run things. Okay, so during this time, one of the midnight judges that didn't get his commission, William Marbury. Consider this: when John Marshall and John Adams left office, there were a few judges that didn't receive their commissions in time, and it was the Secretary of State that was handing these things out. So when James Madison and Thomas Jefferson came into power, and they saw that these commissions had not been delivered yet, Thomas Jefferson instructed James Madison to disregard them, throw them away, whatever, forbade him to deliver them. James Madison complied with his boss's directives, and these individuals didn't get their judgeships. Well, with the help of Charles Lee, a former United States Attorney General for Virginia, William Marbury brought a suit against James Madison in the executive branch of the United States. Marbury versus Madison was between William Marbury and James Madison. Now, again, William Marbury was a POS of the first order. He was a slave owner and a slave trader. His name multiple times popped up in the paper where he was selling slaves. Okay, that matters because these are the people that are running our government and telling us that we have to submit to them. Slave owners, slave traders, reptiles, okay? William Marbury had been removed from positions previously based on being a degenerate, based upon not being able to do his job effectively. He was effectively fired from those positions in government. Now, he brought this suit against Madison, and what's interesting about this is that James Madison and Thomas Jefferson refused even to answer the petitions. They just stayed all the way out of it. Basically, were like, decide however you want it. There was rumors that there would be war, potentially, if John Marshall tried to issue a writ of mandamus against Thomas Jefferson, which is essentially an order by a judge saying that an official from another branch or an official of some sort has to do something specific. It's in accordance with their duties. They're forced, they're compelled to do what they're supposed to do, even if they don't want to. So, John Marshall was looking to strike this Judiciary Act down, and in so doing, said that any act that was perpetrated by the Congress that was repugnant to the Constitution is void. Well, in the same breath, he declared that basically the Supreme Court's the benefactor or the protector of the people, and it's to them to decide if something's repugnant to the Constitution or not. Now, previously, it was the states that decided that. State courts decided whether or not something was unconstitutional. John Adams, who affixed, let me see here. Let me see where I'm at here to get us up to speed. I went off a little bit on a tangent. I just have some few notes here and there to kind of keep me going. You know, I like to get off on tangents, and this is a very important issue. So, with the help of the former U.S. Attorney General General Virginia Charles Lee, Marbury sued James Madison and Jefferson together in this case. Now, it's also interesting to note that Thomas Jefferson, just to bring these conspiracies all the way around, is that Thomas Jefferson was the blood cousin of John Marshall. Okay, and another side note, John Adams was the blood cousin of Samuel Adams. Okay, now John Adams persecuted and prosecuted Sons of Liberty over alleged mistaken shots fired and some British redcoats killing Americans. And then ultimately Sam Adams allowed John Adams to get away with that and to defend these guys and get them off after they killed Bostonians, but then welcomed John Adams into their committees. It's all a scam. They're all related. And it's all a scam. And Marbury versus Madison is one of the pinnacle points of this whole thing. Again, like I said, Madison never responded, never had the Attorney General of the United States respond to the complaint. You and I would have went to jail if that happened. If we were summoned in court and we said, nope, we're not going, we're not answering, we would either have a serious judgment against us, probably economically destroying us, or we would have warrants out for our arrest. Obviously, that doesn't apply to Hillary Clinton, Prescott Bush, rather. You know, people like that, Paul Warburg, these guys with big, huge war crimes behind their backs, Bill Clinton, George H.W. Bush. Nobody like that's going to stand trial or have anything to worry about if they refuse to stand trial, but of course we would. Now, Marshall's opinion, again, back to Marbury versus Madison, is the epitome of reptilian design and control. Marshall held that it did not have the authority, the Supreme Court did not have the authority to enforce a mandamus against a president of the United States. Excuse me. Because to do so would be an encroachment upon another branch and would be in violation of the separation of powers, you know, like the House and the Senate, the legislative branch, the president being the executive branch, and the Supreme Court being the judiciary. The separation of powers, so to do so would be against that. Again, a moot point. There was no grounds ever, according to John Marshall, for that to happen, and in any case, he gave a lengthy decision, basically admonishing the Jefferson administration while ultimately deciding he had no authority to decide the case or to rule in Marbury's favor. So, a scam. Again, a scam. It's very important to remember those points right there. Those are major, those are fundamental points. No right to make the decision. They're not doing that today. If they shoot a decision down, they generally won't even get any type of opinion published at all. They'll just say there's no grounds for this case. We can't hear it and let it go. That's not the case in Marbury versus Madison. Now, in the same breath, while he was saying this is where I talk about the reptilian speak, the design, the control, is that in saying that anything repugnant passed by the legislature is void, he also says, and it goes on to purposefully misinterpret Article 3, Section 2, Clause 2 of the United States Constitution, empowering the Supreme Court of the United States. And grants the Supreme Court original jurisdiction. Now, the article specifically quoted says, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party. That's it. Did you hear anything else? That's it. You ready? The Supreme Court has original jurisdiction in those cases. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Congress gets to decide what they can do. That's no longer the case. In Marbury versus Madison, what Chief Justice John Marshall said, he purposefully misinterpreted the Constitution, and he said Justice Marshall interpreted a new state of the law known as judicial review. Under this doctrine, the Supreme Court has the sole authority and right to say what the law is. As law professors can be heard shouting to their students across this land, it doesn't matter what the Constitution says. It only matters what a majority of the Supreme Court says the Constitution says. This is penumbra doctrine that's created from the spectrum of your vision. You see this, you interpret this. That's not constitutional interpretation. It's penumbra doctrine. It's in-graft. You're taking a little bit from this, you're ripping it off, and you're grafting it to this over here to give yourself more power. That's what our system does, and that's what Marbury versus Madison did. It is the colorable fiction law perpetrated by our reptilian overlords. From Jefferson to Marshall, from Washington to Roosevelt, into modern times as Kevin McCarthy, Joe Biden, John Roberts, Nancy Pelosi, Josh Hawley, Ted Cruz, and all of the rest. At the end of the day, Marbury versus Madison is the deed to America. And that deed is in the hands of an evil priesthood masquerading as just law speakers, protecting the liberties of the people they hold in chains. All this from a decision issued on a moot case in which the court admitted it had no authority. Our constitutional rights are better protected as fundamental rights protected by the Creator. If we have to cite cases, in my experience, the cases I have cited generally apply specifically to the constitutional violations that I would be fighting, whether it's right to travel or anything else. And I would use those cases as a matter of their own common law, which is case law in their law venue. So I would use those such cases as United States versus Kiss or Hale versus Hinkle. But cases that show that they have no power over you, meaning they, the judiciary, as well as the legislative and executive branches. In Marbury versus Madison, John Marshall says to the world that the judiciary has the sole prerogative to tell you what the law means. So even if you read a law to say something in black and white, if you cite Marbury versus Madison, you're conceding that they have the right to say that it doesn't mean what the words are telling you. That it actually means, in accordance with penumbra and in-graft doctrines, that it means what they say it means. Now, I hope this was informative. This is a subject that I love more than many others, Marbury versus Madison and the great conspiracy that happened following the ratification and the great decision. So I hope you enjoyed yourself as well. But in the meantime, stay tuned, stay sovereign, and do not consent.